Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. Today, we're going to talk about a case out of Texas, and it raises an interesting question. Should we expect judges to be dispassionate? Should we expect them not to be angry or upset when bad facts are introduced or when things don't go as they believe they should go? Or do we expect judges to be human? And if we expect judges to be human, then we have to expect that at sometimes that humanity might very well go beyond what is supposed to be a judicial temperament. Because the judicial temperament is supposed to be one where someone is quiet, thoughtful, contemplative, and wise. And that is what you're looking for in a judge. Now, does that mean you always get that? No. There are some real clowns out there wearing black robes, but that is not really the subject of this video. The subject of this video is a judge in Texas who was hearing a particular case. This is the case of MD, my next friend Sarah Stukenberg, and a whole bunch of other people versus Greg Abbott, the governor of Texas, in his official capacity, Cecile Irwin Young in her official capacity as the Executive Commissioner of Health and Human Services, and Stephanie Muth in her official capacity as Commissioner of Texas Department of Family and Protective Services. This is an appeal from the United States District Court for the Southern District of Texas, and it is Judges Jones, Clement, and Wilson, the circuit judges, who are deciding this. In their fourth appeal from court orders that awarded permanent injunctive relief designed to overhaul the Texas foster care system, the state defendants challenge a contempt order and $100,000 per day ongoing fines. The state raises numerous defenses against the sanctions, including that the order constituted criminal contempt, lacking constitutional safeguards, and that the fines violate the 11th Amendment. The defendants contend that the state is in substantial compliance with the remedial decree. And finally, because of the judge's intemperate conduct on the bench, they seek her removal and reassignment of the case to another district judge on remand. The court says we vacate the contempt order, hold that the state has substantially complied with remedial orders 3 and 10, and remove the district judge. It is a very rare thing when a federal circuit court of appeals removes a federal district court judge from a trial. Usually, if the court is unhappy with the way the judges handle things, there will be rebukes. Most of the time, those rebukes are in private. Somebody picks up the phone and calls and says, hey, this better not happen again. Things like that. Those are the kinds of things that happen behind the scenes, but not usually in a written opinion. When I first opened up this case, I knew that the misbehavior, so to speak, of the judge had to be pretty significant. Now, they don't go into a whole lot of information about the background of the case, but basically, the background is that the Texas foster care system was a disaster from start to finish. They are supposed to take good care of these children. They are supposed to place these children with foster parents who give them the love and attention and affection that they deserve, while the state works on rehabilitating or outplacing them for adoption, whatever it is. Unfortunately, because the state also pays foster parents, many times what happens is you wind up getting foster parents who are just in it for the money. To shorten this somewhat, the district court had issued orders in an injunction that required the state to do certain things. And two of those orders are at issue here. Numbers 3 and number 10 required certain things of the state, and the state was found to be not in substantial compliance with those requirements. The district court imposed a $50,000 daily fine for each order until the Health and Human Services Commission leadership certifies that it's substantially compliant with the orders. The fines therefore total a total of $10,000 per day. Remedial Order No. 3 requires the Department of Family and Protective Services to ensure that reported allegations of child abuse and neglect involving the children in the permanent managing conservatorship class are investigated, commenced and completed on time consistent with the court's order, and conducted taking into account at all times the child's safety needs. Remedial Order 10 requires, in relevant part, that DFPS, within 60 days, complete Priority 1 and Priority 2 child abuse and neglect investigations that involve children in the PMC class within 30 days of intake. Order 10 permits extensions of the deadline for good cause when documented in the investigative record. Together, these orders essentially required the defendants to investigate child abuse and neglect allegations in a timely manner, which is what you would expect. The district court held Commissioner Young in contempt because Provider Investigations, a unit within the HHSC, failed to comply with these two orders in handling of 38 abuse and neglect allegations, which involved 13 children. In an order dated April 15, the district court ordered Commissioner Young to pay $50,000 per day until HHC agency leadership certified that all provider investigations involving at least one PMC child closed from December 4th, 2023 until the date of the state's certification are substantially compliant with the Remedial Order No. 3. Another $50,000 per day fine was imposed until the leadership certified that all open PI investigations involving at least one PMC child are substantially compliant with Remedial Order No. 10. This court, meaning the circuit court, stayed the contempt order on May 20th. The standard of review. The court reviews the district court's orders for abuse of discretion, but a district court by definition abuses its discretion when it makes an error of law. The issues here are purely legal. So the first thing had to do with the type of contempt. There are two types of contempt: civil contempt and criminal contempt. Civil contempt is meant to be a coercive sanction. In other words, for example, you're going to stay in jail until you write a check for this outstanding child support. Or in this case, you're going to pay $10,000 a day until these investigations are completed. Criminal contempt, however, is to essentially vindicate the honor of the court, and criminal contempt is always subject to due process protections. And the court says, rather than beat a dead horse, we're just going to repeat a portion of the opinion that we issued when we stayed the appeal, following the comments by the parties. There are two types of contempt, civil and criminal. Criminal contempt is a crime in the ordinary sense, and criminal penalties may not be imposed upon someone who has not been afforded the protections that the Constitution requires of such criminal proceedings. In contrast, civil contempt sanctions may be imposed in an ordinary civil proceeding upon notice and an opportunity to be heard. For civil contempt sanctions, neither a jury trial nor proof beyond a reasonable doubt is required. The contempt power of courts, as Bagwell, a case, explained, is rooted in concepts of necessity and arbitrariness. Necessity requires the courts be able to enforce their judgments and orders. Arbitrariness in imposing sanctions is a threat endemic to those who hold power that must be confined. Where a contempt order is deemed criminal, arbitrariness is cabined by the requirements of a criminal proceeding. In other words, the judge just can't go off half-cocked. Whether a contempt order is civil or criminal turns on the character and purpose of the sanction. And here, without going through a lot of additional work, what the court determines is that it was a criminal sanction and not a civil sanction. And here's one reason why. The April 15 order requires defendants to pay $100,000 per day until they certify that investigations closed from December 4, 2023 until the date of the state's certification are substantially compliant with remedial order number 3, and that other open investigations comply with remedial order number 10. Defendants can do nothing to render an already untimely investigation timely. The court's order, after all, specifies that investigations that were closed months before April 15th and open investigations that may become untimely vis-a-vis remedial order 10 before 15th are the subject of the sanction. Moreover, the defendants cannot complete open investigations or correct past investigations that fail to adequately consider the safety of the children overnight. But that is exactly what the court's order requires by imposing per diem fines that begin immediately. In other words, you went a little bit overboard here, Judge. You didn't think through this particular order, even though it took you 427 pages to write it. And the court points out that not only are the terms of the contempt order at odds with a rational path to substantial compliance, but the plaintiff's own conception of substantial compliance is entirely hypothetical. Plaintiffs assert that the state can substantially comply by documenting good cause for extending PI investigations that were already out of date when the court issued its April 15th order and by quickly finishing its delayed investigations. But as just noted, the court ordered substantially more than those basic tasks. Ultimate suspension of the fines seems to lie in the court's subjective notion of compliance. So when you have a contempt order, what you don't want is the judge deciding by some subjective standard whether you're in compliance. You want to be able to show objectively that you are in compliance, and if it's all in the judge's head, it's really hard to do that. The court also found that the criminal contempt sanctions here, like those at issue in other cases, they punish the state's past malfeasance, and that's a violation of the 11th Amendment. When you have a criminal contempt sanction as opposed to a civil contempt sanction in an 11th Amendment context, that is what violates the 11th Amendment. You can't punish a state actor criminally for a violation of a court order, but you certainly can throw them in jail until they comply. Then the court took up the issue of substantial compliance. It says if the plaintiffs had succeeded in showing contempt, which they didn't, the burden would shift to defendants to show substantial compliance, which is an absolute defense to civil contempt. The court considered the good faith or lack thereof. So here, the state endeavored in good faith to comply with the court's orders. For example, it spent over $100 million overhauling internal policies and lobbied for additional assistance from the Texas legislature. The district court's contempt order never found bad faith. Whether compliance was done in good faith or bad faith is relevant when it's substantial, and the district court recognized the reasonableness of the alleged contemptors' attempts to comply is the touchstone of a substantial compliance defense. And whether compliance was reasonable and substantial turns at least in part on whether defendants were acting in good faith or bad faith. And so if they didn't find bad faith, then again, it doesn't fly. Now let's come down to the really interesting issue in this. The final issue in this appeal is defendants' request that this case be reassigned to a different judge on remand. Reassignment is an extraordinary power and should rarely be invoked, and it is rarely invoked. We have carefully considered the record and the applicable law before concluding that this case must be reassigned to another judge. As this court originally found, the state of Texas had seriously neglected the management of its foster care system, resulting in constitutional violations against vulnerable children that this court affirmed. Nearly a decade has passed since the district court entered its first judgment ordering remedial relief. This state has been under constant, intrusive, and costly surveillance by a team of monitors and the district court ever since. The state asserts without contradiction that it has spent $150 million in attempting to comply. But not only has the district court clearly indicated an intent to continue oversight well into the future, but as will be seen, this contempt order seems a harbinger of even more drastic district court micromanagement. Against this backdrop, we've had to decide the difficult issue of removal. This court has not decided which of the two tests should be used to decide whether to reassign a case. Under a more formal approach, this court considers three factors: whether the original judge would reasonably expect it upon remand to have substantial difficulty in putting aside her previously expressed but inappropriate views, whether reassignment is advisable to preserve the appearance of justice, and three, whether reassignment would entail waste and duplication out of proportion to any gain in preserving the appearance of fairness. The court also asked a more straightforward question whether the judge's role might reasonably cause an objective observer to question the judge's impartiality. And they say basically, so not only can actual bias or prejudice have to exist, but it can, if it appears that there's actual bias, then each test essentially leads to the same place. This court analyzes the two tests together because of this redundancy. Beginning with the first factor, a judge might reasonably be expected upon remand to have substantial difficulty putting aside previously expressed but inappropriate views when there has been a repeated failure to follow the mandate of an appellate court. So the three strikes in this case for modifying the injunction, I think maybe that played very heavily into the judge's decision here to remove the district court from the management of this case. And indeed, that's pretty much what they decide. Our comprehensive review of the district judge's conduct through the 3-day contempt hearing in December that brought this issue to fruition repeatedly exhibits a highly antagonistic demeanor toward the defendants. The district court, to begin with, urged and instigated plaintiffs for several months to seek contempt. During the hearing, the judge repeatedly questions the defendant's unwillingness to exceed the requirements of the remedial decree. Quote, I told the state that this has not anything to do with the court, but that they have resources in these monitors that they can use. Nothing. And toward the end of the hearing, it doesn't hurt to go over and above, not just the minimum standards, but over and above. So if you wanted them to go past the standards that you set, you should have set higher standards, Judge. That's sort of the way orders work. So the defendants got a win all the way around. But you have to remember that this win comes only after the plaintiffs established constitutional violations and got an injunction in place that, although overbroad and modified repeatedly, still the state had trouble complying with it. And so there had to be some additional work to try and enforce it. And in reality, the district court wasn't wrong in trying to hold their feet to the fire. It simply should have lit a smaller flame, I think, is what the Circuit Court of Appeals is saying here. A lot of times, and I would point out that the judge here is repeatedly referred to here as a her, and the judge was clearly bothered by the way that the children were abused in this situation. When you have children serially abused by a foster care system, it does speak to a requirement to act with immediacy and to be forceful in invoking a remedy. I can't find any fault with the judge setting high standards. What I find fault with is her setting unattainable standards. I do think that in many respects, Texas has cleaned up its foster care system. And I think this lawsuit could be filed in pretty much any state in the country. Because even though bureaucrats are always entrusted with the oversight and care of children who have been abused and neglected, it is quite often that they fail to meet the requirements of their job. And when 5 o'clock comes on Friday and things are left undone, oh, well, I'll be back Monday and I don't get paid overtime, I get paid a salary. Sometimes that kind of thinking can have a terrible effect on a child. A child that undergoes the kind of tortures that these children went through for another 48 or 72 hours, that's not a minimal thing. And so, again, I'm glad that the plaintiffs brought the case. I'm glad that the court imposed an injunction. And I'm glad that the Circuit Court of Appeals pushed back on that, had it narrowly tailored, and circumscribed the district court's discretion to prior times before finally saying, okay, you are not the judge to manage this case. It'll be assigned to someone else, and at some point, a better judge will ultimately decide that no further oversight is necessary. So since we had that case from Mississippi the other day where the children were put in foster care because their mom and dad were both drug addicted people, I thought it appropriate to point out that that is not a panacea, and this case happened to pop up on the radar just the other day, and I thought, this is an interesting counterpoint to that Mississippi case. I would also point out that if you're looking for a way to do kindnesses for people, as I often talk about, being a foster parent is an excellent way to go. When we lived in Missouri, the lady across the street from us was a foster parent, and she had kids that she had fostered for years come back to her as adults and sit down and have dinner with her and share their life experiences and thank her for what she did. Being a foster parent is and can be a very difficult job to have, but it is also one of those jobs that will, at some point, love you back. That's what I have for you today. Thank you so much for watching. If you have the opportunity today, do a kindness for somebody. If you have any questions, drop them in the comments down below. Email me at the address above, and then come on back tomorrow. Join me down here at the beach. We'll talk about something else. Have a great day. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.